Having examined the duties that continue after an agency relationship ends, we now turn to the critical boundaries of what a real estate licensee may not do once that relationship is terminated. The distinction between what duties remain and what actions are prohibited is central to maintaining compliance under Arizona law. While the previous section emphasized ongoing obligations of fairness, confidentiality, and honesty, this section focuses on the limitations of authority and representation that apply once the fiduciary relationship is no longer in effect. These boundaries are designed to prevent unauthorized practice, protect consumers, and uphold the integrity of the real estate profession. Under ARS Title 32, Chapter 20 and Commissioner's Rule R4-28-1101, the authority granted to a real estate licensee exists solely within the scope of an active agency agreement. Once that agreement ends, by expiration, mutual termination, or operation of law, the licensee loses the legal right to act on behalf of a client. This includes the loss of authority to negotiate terms, prepare or alter contracts, or make representations concerning another party's interests. Any attempt to perform such tasks without a valid agency relationship may constitute unlicensed activity or misrepresentation under ARS Section 32-2153A3. A licensee, therefore, cannot continue to perform tasks that imply representation. For example, a former agent may not advise a buyer on how much to offer for a home, draft a counteroffer, or communicate terms to a seller after the termination of a buyer-broker agreement. Such conduct gives the appearance of acting as an agent without authorization. The Arizona Department of Real Estate, ADRE, has consistently disciplined licensees for continuing to act after termination, even if their intentions were helpful. In disciplinary hearings, the ADRE emphasizes that representation must be renewed in writing before any new act of advocacy or negotiation occurs. Consider a real-world example. A listing agreement expires on June 1st, but the agent continues to show the property to potential buyers and communicates offers to the seller. Even though the relationship was positive, these actions are unauthorized because the agent's legal authority ended with the expiration of the listing. If the seller accepts an offer generated during this unauthorized period, the agent could face denial of commission and potential disciplinary action for misrepresentation under R4-28-1101A. The agent could also face civil liability if the buyer or seller claims to have been misled about the agent's authority. Similarly, a property manager whose contract has been terminated may not collect rent, sign leases, or disperse funds after termination. Doing so would constitute acting without a valid management agreement under ARS Section 32-2173, which requires all management activities to be conducted under written authorization. The broker's trust obligations under ARS Section 32-215-1.01A continue for existing funds, but all operational decisions must cease immediately upon the end of agency. Another limitation concerns the unauthorized practice of law. Under Article 26 of the Arizona Constitution, real estate licensees are permitted to draft and fill in real estate forms related to transactions they are directly involved in. However, once the agency relationship ends, this authority also ends. A former agent cannot prepare or revise contracts, deeds, or lease documents for a client, even as a favor. Doing so would violate both the Statute of Frauds, ARS, Section 44-101, and the prohibition against practicing law without authorization. The landmark case, State Bar of Arizona versus Arizona, Land Title and Trust Company, 1961, established that real estate professionals may complete contracts incidental to their own transactions, but not beyond. Once representation ends, this incidental authority disappears. Licensees also cannot continue using the client's confidential information or property details after termination for personal or business gain. For instance, a licensee cannot contact buyers who previously made offers on a former client's property to market other listings. Such actions may breach confidentiality and violate R4 28 1101E, which prohibits the misuse of client information obtained through agency. The continuing obligation of confidentiality exists to prevent conflicts of interest and protect consumer trust even after representation ends. Another limitation arises in advertising. A licensee may not advertise, market, or display signs for a property without written consent from the owner under R4 28 502. Therefore, after agency termination, all advertisements must be removed immediately. Leaving a for sale sign on a property after a listing expires gives the public the false impression that the broker still represents the seller. ADRE routinely issues citations for such violations, as they constitute misleading advertising and unlicensed activity. There are also ethical limitations regarding client communication. Once representation ends, a former licensee may not attempt to interfere with another active agency relationship. Doing so violates R4 28 1101D and Code of Ethics, Article 16, which prohibits inducing another party to break an existing agreement. For example, if a former client hires a new broker, the previous agent must not contact the client with offers of better commission rates or different terms. This type of interference, known as tortious interference with contractual relations, can lead to both civil and administrative penalties. It is also essential for licensees to understand that fiduciary duties such as loyalty, obedience, and advocacy cannot be selectively performed outside of agency. A licensee cannot choose to help a former client by suggesting negotiation strategies or recommending counteroffers while claiming they are not officially representing them. This creates implied agency, exposing the licensee to liability without the protection of a written agreement. Under R 4 28 1101D, implied agency occurs when a licensee's actions lead another party to reasonably believe representation exists. This can result in legal and ethical complications that ADRE and the courts interpret strictly against the licensee. In summary, once the agency relationship ends, a licensee must stop acting as an advocate or decision maker for the former client. They may continue to act ethically, honestly disclosing material facts, maintaining confidentiality, and handling any remaining financial or documentation obligations. But they may not perform acts of representation, negotiation, or contract preparation without reestablishing a new written agency agreement. Review summary. When an agency relationship ends, a licensee loses the authority to perform fiduciary and representative acts. They may not negotiate, draft contracts, advise on strategy, advertise the property, or interfere with other agency relationships. These limitations are governed by ARS Section 32.2153A3, R42.81101A, D, and E, and ARS Section 32.2165A. Unauthorized actions after termination may constitute unlicensed practice or misrepresentation. The continuing duties of confidentiality, honesty, and accounting remain in effect, but all advocacy and transactional authority cease immediately. Discussion: why can a licensee not draft a contract for a former client after the termination of agency? Answer: because the licensee's authority to prepare contracts under Article 26 of the Arizona Constitution only applies to transactions in which they are directly involved, and that authority ends when the agency relationship terminates. What must a licensee do with all signs and advertisements once a listing expires? Answer: all advertising and signage must be removed immediately Under R4 28 502C and R4 28 502I to prevent misleading the public. What is the risk of providing advice or negotiation guidance to a former client without a written agreement? Answer. It can create implied agency under R4 28 1101D and result in liability for unlicensed practice or breach of professional conduct. Closing remarks. The end of an agency relationship does not erase professionalism, but it does establish firm boundaries. Arizona law clearly limits what licensees may do outside of active representation to prevent confusion, conflict, and misconduct. The true measure of a real estate professional is their ability to respect these limitations while maintaining honesty, confidentiality, and ethical behavior. A disciplined adherence to these principles not only ensures compliance, but strengthens public confidence in the profession as a whole.